state in this honorable court.
Good afternoon. Our next case is Merrill, Arter versus Orange County et al. And I'll note that Justice Riggs is recused. We'll hear from the appellant.
May it please the court, Chief Justice and Associate Justices, my name is Andrew Pettish. I'm here representing the appellant, Allison Arter. I'd like to reserve 5 minutes for rebuttal. This is a case about an error made by the Court of Appeals that impacts a fundamental issue for property owners in North Carolina, specifically the impartial, fair, and equal enforcement of lawfully adopted zoning laws. Specifically here, the question is whether the interpretation of Orange County's Unified Development Ordinance, or UDO, will be construed according to established principles and give effect to a required land use buffer between appellant's property and an adjacent residential subdivision. Ms. Arter owns a 12-acre property where she resides and operates a horse farm. She bought that property in 2007 from appellees Stephen and Sharon Burt. That property was attractive to her to purchase specifically because it had existing infrastructure designed to support a horse barn. That included a barn with horse stalls and tack room. It had horse pastures, run-in shed, and an eventing arena. Circa 2020, the adjacent 17-plus acre parcel to the immediate south was undeveloped, remained undeveloped. It was also owned by the Burts. That parcel, it turns out, was in line to be acquired and developed by appellee Jody Bass, and it would be combined with a roughly 38-acre parcel that was located to the east. That combined 55 acres would become the Array subdivision. Once Ms. Arter became aware of this project, she reviewed the proposed subdivision plans and the UDO. Both the Arter property and the subdivision property are zoned R1. They're located in R1 zoning districts. And that normally would not trigger any buffers between those two properties. Ms. Arter noted, however, that according to the UDO's land use buffer table, a 30-foot buffer would be required on all property lines that the Array subdivision shared with active farm or agriculture uses. Given Ms. Arter's ongoing operation of a horse farm on her property, she believed that that 30-foot buffer should apply.
So our case law says if there's any ambiguity in a zoning ordinance, we have to construe it in favor of the free use of property. We're essentially saying to the government, to municipal governments, you have to write clear zoning rules. If you don't, then whatever people want to do with their property is fine. And so if we apply that principle here, it would mean that your client's going to lose, not because the government's going to win, but because the property owner who wants to just use their property for whatever they want is the subdivision. And if they don't want to build the buffer, they don't have to unless the zoning ordinances unambiguously require it. So I guess my first question to you is, when I look at both what the majority is saying and what the dissent is saying, it didn't seem to me that there was a clear, unambiguous answer to the question of what the scope of these requirements is. So why is it so clear that you have to consider an agricultural use if there's one that's zoned R1 but it's not an active farm? Then next door you got another R1 but it is an active farm. That unambiguously in these provisions you would have to build a buffer. Can you walk me through why that is, in your view?
First, I would submit that that principle that zoning is in derogation of the free use of property is utilized as one of the canons of interpretation, and it is not the trump card with respect to anytime there's ambiguity within an ordinance. In the Yancey case, for example, there the court was doing statutory interpretation of a zoning ordinance with respect to whether the permitted use of a school within a zoning district could be extended to ancillary school uses such as sports facilities. In applying this principle of zoning being in derogation, the court there pointed out that it would not defer to some ambiguous interpretation of that ordinance when the language was obscure. And there, we were talking about the question of, okay, schools are permitted. Are we going to then extend that to the typical uses that are accompany schools in the modern day and age? At least at that time, they referenced the small red schoolhouse days being passed. And
See, I would argue that what's going on there is they're just using other tools of statutory construction, sort of that traditional toolbox, to conclude that there's no true ambiguity, that there is a way, there is one interpretation of the statute that is, so warranted that you can't say there's two reasonable interpretations, sort of at equipoise, where you can't, it's difficult to choose between them. And here it seems, that's what I'm looking for, is for you to give me sort of the tools in the toolkit that we can walk through this and say there isn't a kind of a direct conflict between B and D, that there isn't a bunch of confusing stuff between is this a table, is it not a table, is it the text, all those sorts of things. Like, how are we figuring that out?
thank you for the clarification. So the established framework for statutory interpretation, municipal ordinances are construed the same rules as state statutes. Those rules provide that where the language of the ordinance is clear, the courts must give it its plain and definite meaning. In this case, everybody's agreed that there's ambiguity within the land use buffer section, and that's UDO section 6.8.6. Where the statutory language is ambiguous, courts utilize canons of judicial construction to interpret that meaning. And the basic rule to start out with is that the court should ascertain and seek to ascertain and effectuate the intent of the legislative body. Courts must also consider relevant sections of the ordinance and read those as a whole, and provisions to be construed in pari materia. And courts should also strive to avoid absurd results and illogical or illogical results.
Can I ask you, doesn't the ordinance itself also give us, in essence, a canon of construction that we're required to apply here? And that's section 1.1.2, which says that the headings and illustrations, and it specifically says, in the case of any difference of meaning between the text of this ordinance and any heading, drawing, table, figure, or illustration the text controls. Don't we have to also apply that here?
Yes, Justice Earls, that must also be applied and considered in this. And I will work this through to your question, Justice Teets, together. So what the majority in the Court of Appeals did in their analysis, and what all the tribunals leading up to that have done in their reviews, they've focused in on just two sections of the buffer requirement, and that construction section, providing guidance on construction, 1.1.12. And the analysis has ignored other sections which are required to be considered by those canons of construction. So I would begin the analysis by considering all four of the sections, or the first four sections in 6.8.6A, purpose, where that discusses the intention of this section, and that land use buffers are intended to screen and buffer lower intensity density uses from incompatible higher intensity density land uses. The next section is where most of the attention has gone with respect to the ambiguity, the inconsistency between the table and the text. And that is where it states that land use buffers will be required based on the zoning district of the proposed use and the zoning district of the adjacent uses. However, in subsection C, this text clearly contemplates that required land use buffers shall be located along interior and street lot lines nearest adjacent streets, land uses, and/or zoning designations. So there's no limitation there to simply zoning districts. So subsection C1 is entirely consistent with the buffer table. I would say Part A is also entirely consistent. The inconsistency comes from section B, potentially. And that's what the reviewing tribunal says focuses only B and the table in context with the guidance in 1.112. But then no other canons are considered in the process. And as I stated, parts A and C are ignored. And so what I would submit is that when the ordinance is read holistically, and those provisions that are addressing the same subject are looked at consistently, and with a focus on the intent of the ordinance, not only Part A there, but also reference other UDO sections 1.14, 1.17, which incorporates the intent of the and purpose and guidance and the adopted policies of the comprehensive plan. And also 1.1.8, which addresses the regulation of farming and bona fide farm activities. When that lens is pointed at this question of statutory interpretation, I don't believe this becomes an obscure meaning, but rather there's clarity here that the intent, surely by the Board of Commissioners of Orange County, was to apply not just the active farm and agricultural column in the table, but also the interstate highway, arterial street, and collector street, which, if the Board of Adjustment, Superior Court, and Court of Appeals readings hold, would all be voided, and that would result in the absurd and illogical result here.
Well, I mean, to Justice Earl's point, though, if you read B and you just follow, which is definitely text, and B says the buffer's based on the zoning district of the proposed use, the zoning district of the adjacent use, and then you look on the table, you're in like the very top left, because you're in an R1 and an R1. And what you're saying is go down to look at some other things in the table that are, I think no one is suggesting are zoning districts. You know, an interstate highway is not a zoning district. I think the argument would be, well, there's an interpretive provision at the beginning of the ordinance that says you disregard the tables. Now, I understand your point, which is, but then you go to this and look and say, well, why would the drafters have put these in here knowing that they are meaningless, when this seems to be the sorts of things that's very consistent with the spirit of what they're trying to do with the buffer provision, because these are exactly the sort of things, interstate highways, active farms, where the buffer would be so important. To me, that creates an ambiguity, the true type of ambiguity I'm talking about, not a one where you can use tools to resolve it, but where I just don't know what the drafters of this were trying to get at. But if that's the case, what I'm struggling with is, I think our precedent says your client loses in that circumstance, because in that circumstance, you can't make somebody do something with their property they don't want to, if the rules are truly ambiguous. So what's your response to that?
The second part of that is that in this case, because we're dealing with buffers, that is, the buffers are created for the purpose of inuring to the benefit of adjacent property owners. So in this case, you have two property owners that you would apply this principle to. That to say that we're going to interpret this zoning so that there is no buffer and now you're harmed, that would be in derogation of my client's rights.
So are you suggesting that the presumption is in favor of these buffers as opposed to the presumption being in favor of the free use of land?
No, I'm not saying that, Your Honor. I'm saying that in this case, the ambiguity can be resolved. That this can be read in a harmonious way. And one way that that can be done is to consider that this property has been determined to be a bona fide farm, and therefore it is exempt from zoning requirements. And I believe that that is one of the core reasons why this was included. Because not only could you end up having a bona fide farm that is operating in R1, which is already a more rural zoning designation, but it can also operate in an industrial, in a heavy commercial, office, any of the much more intensive districts. And therefore, its place within this chart fills a role where there really is no zoning that applies. It is exempt from that zoning district. So you're not comparing one for one. That base zoning district is irrelevant. It's unenforceable. And therefore, this column then fills in when there is no zoning district to apply. So I would submit that that, again, is one of the other factors in which this is unique and not in complete alignment with many of the cases that discuss zoning and derogation of property rights. And so when you take all these factors together, it leads to a reading of this that resolves the ambiguity. There is no, in this case, these zoning districts are still protected. This doesn't lessen in any way or interfere with buffers that are being applied between zoning districts. It is therefore additive, and in that way, it's not negatively impacting what is provided for in B.
So just to make sure I understand, so as I look at the table, it seems like, well, yeah, there is ambiguity, because you could look at it and you could say, this is R1 and R1, and therefore there's no buffer requirement, if you look at it that way, right? But if it's R1 and active farm, then there is one. Is there anything in here that tells you when the requirement would vary based on whether you're looking at the zone or the use, which one you go to?
That is a factual determination.
Isn't that an interpretive interpretation? Or an interpretive issue, though?
Well, in this case, they would, the use of active farm or agriculture would have to be established through some methodology, and this is an issue that the county raised, but that is one of the core functions of planning staff, is to analyze the adjacent properties and make a determination with respect to which applies.
What I'm trying to get at is, does the ordinance say, well, if it's a use that triggers or that involves a buffer requirement, you look to that instead of just the category of the district? So you don't look at the fact that it's R1, you look at the fact that it's an active farm. Does that make any sense?
It does, Your Honor, and I would submit,
You can say no if it doesn't.
I believe it does, and I would submit that there is no clear guidance.
So here's where I have, I'm trying to frame this. I think the dissent makes a lot of sense if you just stop at, we interpret ordinances, we apply the same rules to ordinances that we apply to legislation. Because if we are asked to interpret a mass of legislative provisions, and there seems to, and some of them are ambiguous, what we're going to try to do is we're going to try to determine what the intent of the legislature was and give effect to that. But to tie in with what Justice Steets was saying earlier, in the context of local government zoning, there is this presumption in favor of the free use of land. And so in that way, our approach differs from how it might, from how we might approach ambiguities in legislation adopted by the General Assembly. So that's where I'm having trouble getting on board with the dissent's approach. It seems like there's ambiguity even within the table itself. And that because of that, we should resort to the presumption in favor of the free use of land.
I certainly understand that line of argument, and I would submit again that in this case, there is a burden placed on my client, on the appellant as well, if there is an entitlement to a buffer and it has an impact on their property and their free use of the property, which she acquired first, and in reasonable reliance on a table that's been published, lawfully adopted, and it existed for years. And I think it is then reasonable, especially in light of the intent and purpose of the ordinance in this particular section, that if you're operating an active farm or agricultural use, especially if that use is a bona fide use and can function in any district, some of those would require 50 or 100-foot buffers from intensive uses, that be enforced. And so there is an inverse quality to this principle that when applied here, I think undercuts the pure application of it to say there's ambiguity here.
But the presumption in favor of the free use of property means, whether I like it or not, my neighbor can do whatever she wants on her property unless there's some valid regulatory prohibition. So that's just a fact of life when you have an adjacent piece of property that you don't own.
I would respectfully submit that that free use of property should also apply to Ms. Harder in this case.
Well, but doesn't she have that, right? She can bargain for a buffer with the property owner, with the subdivision owner. She could have engaged in negotiations to secure land to provide a buffer for herself. It just, it seems to me she's relying, if you're relying on the government, then you have to take the bitter with the sweet. And in relying on the government, one, they may not always do things the right way, and two, you're in essence relying on them to compel someone to do something on their property for which your client could have bargained.
I will say that the parties did bargain, and there is in the record that Ms. Harder offered $75,000 an acre to obtain a buffer, which was, that offer was declined. That's well above market rate. And so that avenue was not fruitful.
No, I understand, and the terms of the negotiation are irrelevant, but at some point, everybody's got their price, right? And if you're relying on the government to compel someone to do something with their property, you have to rely on them completely, I think was my point.
I see I've reached my time. Unless I haven't answered any of the questions, that there's any remaining questions, I'll reserve my remaining time for rebuttal.
Thank you, counsel. You're from the appellee.
May it please the court, Your Honor. My name is Bob Hornick. I'm with the Bro Law Firm in Chapel Hill, member of the Orange County Bar. And I'm here today on behalf of the appellees, Jody Baxt, real estate expert Stephen Burt, and Sharon Burt. I realize that this is the fourth argument today, and you have the pleasure of hearing an exciting land use and zoning argument. I know that always has justices on the edges of their seat. It's what I do every day, so it's perhaps more exciting to me than it is to you, but I appreciate your attention here this afternoon. I hope not to take my entire 20 minutes. James Bryan from Orange County will argue. He's got 10 minutes allocated to him, so we've kind of split up the argument.
Yeah, I think it's convenient that you're arguing first. It's somewhat awkward for the government to stand up and say we win this case because we can't write an unambiguous ordinance. But
You know,
I take it as the lawyer for the property owners that you agree with the principle we've been asserting, which is it's your client's property. And
exactly. We want to start out by saying I think that Michael Harvey in 2021 and the Board of Adjustment in 2022 and the Superior Court in 2023 and the Court of Appeals in 2023 and hopefully the Supreme Court in 2024 will all arrive at the same conclusion, and that is that properly applying the rules of statutory construction or construction of the ordinance should result in an affirming of the decisions below. I want to give you a little bit of a background. Right now, the Array subdivision has been developed. Lots have been sold. Houses are being built. The road is where the road was supposed to be, as shown on the subdivision plat. So we're 5 years down the road, and the development has gone on based on the approvals that have been given. I think it was Justice Earls who I think, from my perspective at least, very astutely pointed out that the UDO already gives us the guidance that we need when we find that there's ambiguity in the ordinance. The UDO, looking first at section, let me back up for a second. Both the Arter property and the Array subdivision property are zoned R1. And according to the UDO, and this is in the record or in the appendixes, the R1 district is the rural residential district. The purpose of the R1 district, and I'm reading from the ordinance, is to provide locations for rural, non-farm residential development at very low intensities. The Array subdivision is located on 55 acres of land has been subdivided into 12 lots. There's 31 acres that will remain open space, 27 acres of which is going to be put into a conservation easement if this litigation ever gets over with. Orange County has delayed accepting the conservation easement until the litigation is done. So we have two uses of property, residential by Mrs. Arter with their claim to have an active farm, which I'll talk a little bit about in a few minutes, but which we dispute, and the low-intensity residential use of the Array subdivision property. You have two compatible uses by the very definition in the UDO. Now let's look at section 6.8.6A of the UDO, which is the purpose section for the land use buffers. Land use buffers are intended to screen and buffer lower intensity/density uses from incompatible higher intensity density land uses. We've already established by looking at the R1 district that the uses of land that we're talking about here are compatible uses. They're both residential uses. So if we're trying to reconcile the provisions of the UDO, I would submit that the purpose for even having buffers to begin with doesn't necessarily apply in this case because you have compatible uses right next door to each other. I would also say we should look at section 1.1.4 of the UDO. It says, subparagraph A, in order to protect and promote the health, safety, and general welfare of the county and its residents, this ordinance is adopted by the Board of Commissioners. Subparagraph B, the purpose of the regulations set out in this ordinance shall be to accomplish compatible development of the land within Orange County. Why on earth would two R1 uses be put next to each other, allowing the uses that are in the district if they're not compatible? I mean, I think that's essentially what the Woodhouse decision that I cited in my brief says, is that if a use is permitted as of right in a zoning district, there's already been kind of a legislative determination that that use is compatible with the other uses allowed in that district as of right. So here we're talking about two properties in the R1 district, two properties that are used for residential purposes. The presumption is that the zoning ordinance and the development ordinance has been designed and intended to create or allow compatible uses. So we've got, I think when you add that all together, we've got to come to the conclusion that the legislative body, the Board of Commissioners, intended for these uses to be allowed next to each other. And why does that fit in? Well, again, we start looking at the table in 6.8.6 D, and looking at the language, excuse me, section 6.8.6 B. 6.8.6 B, land use buffers will be required based on the zoning district, that's the R1, of the proposed use, and the zoning district, R1, of the adjacent uses. So we're told that by the very clear and plain language, the first rule of statutory construction, use the plain language of the statute. That applies to ordinances too. Land use buffers will be required based on the zoning district of the proposed use and the zoning district of the adjacent uses. You have an R1 and an R1, you go to the table at 6.8.6D, and you look at the columns and you look at the lines, and in the matrix, there's no buffer required between an R1 district and an R1 district. I mean, I submit that that's where the analysis ends. You have R1, no buffer required. I also submit that if we look at section 1.1.12, which we've already talked about a little bit, headings and illustrations. Headings and illustrations contained herein are provided for convenience and reference only, and do not define or limit the scope of any provision of this ordinance. Continuing, in case of any difference in meaning or implication between the text of this ordinance 6.8.6B is the text, and any heading, drawing, table 6.8.6D, figure or illustration, the text controls. I mean, that's where the legislative body, the Board of Commissioners, has told us how to resolve this conflict. We don't need to go any further. The rule is right there in the ordinance.
What about the, the point, at least I think I understood your opposing counsel to say that a bona fide farm is exempt from zoning requirements. Is that right? And if so, how does that influence the analysis?
Under, I think it's Chapter 160D 903, I think, is the section of the general statutes now. Bona fide farms are exempt from zoning. That is correct. So that Ms. Arter's property, if it's a bona fide farm, would be exempt from the zoning requirements. Doesn't mean that our property is exempt. It means that her property is exempt. That also doesn't necessarily mean that her property, even though it's got a conditional farmer's sales tax certificate, that may qualify as a bona fide farm, but that doesn't mean that it's an active farm. And I don't want to get too far bogged down in that, but you can have a forest management plan, and that might qualify you, might be sufficient evidence to establish that your property is a bona fide farm for purposes of the statute. If you have a farmer's sales tax certificate, and that's sufficient evidence that you have a bona fide farm. There might be one or two other criteria. You could also have an active farm without any of that. I don't know why you would, but you still could have an active farm where you're actively raising crops or raising livestock or rearing livestock. You could have an active farm that doesn't have any of those 3 or 4 certificates or I'll say certificates that are mentioned in 903D, and be a bona fide farm. What we have disputed and what we say the record in this case demonstrates or fails to demonstrate, really, is that there is an active farm on the Arter property. Again, I don't think the court needs to get to that point if the rules of statutory construction are followed in the first place. But if you do get to that point, I submit that the record demonstrates that in 2021, Ms. Arter was not boarding horses. She's keeping her 2 horses, but she did not have an active farm operation. She didn't have any employees. She hadn't boarded anyone else's horses in at least 4 years prior to that time. She said, and she testified, that she was beginning to organize to think about boarding horses again, but organizing and thinking about boarding horses, in my interpretation at least, does not constitute active farming. Again, what is an active farm? Not defined in the UDO, so it requires some kind of interpretation. All that's a long-winded way of saying is you can be a bona fide farm and not be an active farm as is defined in the ordinance, because bona fide farm, under the proof that Ms. Arter submitted, only requires you to make your application to the Department of Revenue, say that you're going to anticipate spending or generating a certain amount of revenue or spending a certain amount of money. And if you do, you don't have to pay sales tax on certain products that you buy from the farm store. That doesn't mean you're active farming. I also have a potential interpretation. This may be more of Mr. Bryan's bailiwick, but when you look at section 6.8.6D, the table, and you look at all of the zoning districts that are identified, the idea is to protect the adjoining districts from each other. Now, when you get to an interstate highway, Orange County has at least 2 interstates, I-85 and I-40, that have rights-of-way that are a couple hundred feet wide. Those rights-of-way are not in any zoning district. But the buffer is intended to protect the property that's being developed, not the property that's next door. When you're looking at these districts, I think the idea is to protect the property next door to you. When you don't have districts, it looks to me like the idea of the buffer is to protect the property that's being developed, so that Ms. Baxt on her property, she wants to have a buffer from I-40. She's protecting her property interests, not the interests of the drivers driving by on I-40 or I-85. I think it's likewise with the arterial, which is not quite, it's not quite an interstate. It's more like 15501 perhaps, is an arterial. A collector street, which is more like Churton Street, say in Hillsborough, which is not an interstate and it's not an arterial, but it's a collector street where residential streets and local streets all come together. The idea is to provide new development with buffers from those streets. Likewise, I would say that if there were an active farm next door, the reason to require a buffer would be to protect the Baxt property, not to protect the Order property. I think that's a reasonable interpretation of the ordinance, but I don't think you even get there because R1, the rules already tell us how to address that situation. I would like to draw the, in getting ready to close anyway, draw the court's attention to pages 110 and 111 in the record. 110 is an aerial photograph that shows the Ardor property, essentially. You see this kind of a rectangle in the middle of that photograph? That rectangle is the dressage ring. To the right of it is the, it's a barn of some sort. I guess that's where the horses may be aborted. If you look at, and you can see Ms. Ardor's gravel driveway running right beside the dressage ring, right up to the barn on her property. Just below the dressage ring on page 110 of the record, you can see the outlines of the boundary line between the Ardor property and the Array subdivision. And at the very bottom in the middle of the page, you can see the pond that's on the Array property. Now, that was one of the constraints that required or made it necessary for the access drive to be located where it's located, okay? Which is between the pond on the bottom, on the south side, and the common property line to the north of the pond. If you look at page 111, you can see this is the exhibits that are on pages 110 and 111 were submitted by the appellant to the Board of Adjustment. They were part of the Board of Adjustment's record. On 111, you can see this is a draft of the plat, or the near final draft of the plat of the subdivision. And you can see the road running on the left from Orange Grove Road, going, that's on the west, running eastward just north of the pond and just south of the common property line. If you kind of overlay the two, number 10 and page 110 and 111, you can see that there is, near the dressage ring and near the barn, there is way more than 30 feet of vegetated buffer between the road and the property line. Where the property line, where the road is closest to the common property line, you can see on page 1, there's a stand of trees, the vast majority of which remain in place. There are trees between the road on the Array property and the barn and the other improvements on the Ardor property. There's only one little pinch point between the pond and a corner of the Ardor property that juts out where the right-of-way of the road and maybe even part of the road might not be 30 feet south of the property line. But all of this I offer to you because there is a vegetated buffer, almost all of which is way more than 30 feet wide on the Array subdivision property, providing protection to the Arter property if it needs protection. So certainly the spirit and intent of the buffer requirements, if they apply at all, has been satisfied by this plan and was intended to be satisfied by this plan. In closing, I respectfully suggest to this court that it would be appropriate for you to affirm in the majority opinion in the Court of Appeals, to uphold the determinations made by the Superior Court and the current planning supervisor, Michael Harvey, that the buffer requirements of the UDO do not apply in this case, applying the rules of statutory construction. And I'll conclude there unless the court has any questions for me. Thank you.
Thank you, counsel.
May it please the court. My name is James Bryan. I'm a staff attorney for Orange County. Most of it is going to be similar to Mr. Hornick's positions. We take a more narrow perspective. We don't reach the issue of the horses in the farm and stuff like that. There's no record of a similar situation for this particular regulation being applied. So when staff looked at it, they looked at the ordinance and they found it to be ambiguous, which all the parties, all the tribunals all agree. It is ambiguous. The UDO says that sometimes landscape buffers are going to be required.
Let me stop you, because I did hear an argument, and it's a pretty good one, that's not ambiguous at all, that if you read the ordinance's own interpretive instructions, what you basically do is take your hand and starting with in the column where it says interstates till the part about active farm, you just cover that up and ignore it, because there's a difference between that and B, which says you're just dealing with zoning district to zoning district. And so there's no ambiguity, it's just there's a bunch of stuff in a table that's meaningless. That would trouble me, because I think other people looking at the ordinance wouldn't know that, but do you disagree and say your own ordinance has kind of an irreconcilable ambiguity?
Yeah. Yes, Your Honor. I could see that. I think, that's part of statutory interpretation, is that reasonable minds can disagree, and there are different parts of the text where it could make sense. I think fundamentally there's two parts. One is that there is the text that says it's determined by the zoning district, and this is more than zoning districts. That's one clear-cut ambiguity. The other one is, so this is R1, R1. If you were to have R2 as the neighbor, that has a different buffer requirement. So R1, R1 is just a little dash, which you assume is none. But the other one will have, A, B, C, D, E, and F. And sometimes the farm is more required, and sometimes it is less required. And there's no indication for the Orange County staff about what do you do? Is it more strict one do you take? Is it always the farm one do you take? There's just no indication. So we would say that it's ambiguous.
Has the ordinance been amended?
No, it is not, Your Honor.
So you're content to allow the ambiguity to persist?
Your Honor, that is difficult for me to say. I can say factually that it hasn't. I think what I can say in my position is that, like a lot of state legislatures that might have a law on the books that everybody agrees is unconstitutional, but the legislature has yet to strike it down. And why that might be is for a whole host of reasons, but largely it's going to be priority setting of the legislature. So we have amended the ordinance many times since then, but they've mostly been about what I can imagine more pressing issues of affordable housing, environmental cases. We view, I don't want to speak for the elected board, but one might see this as a neighbor dispute. Since it hasn't been applied before this case, and we're not expecting this to come up again anytime soon. So using what little resources we have. Another thing, if I may, it's not in the record, our plan director retired. We've got a new one. He's leaving on maternity leave. We've got lots of different things. But for right now, this is, we've got a 700-page Unified Development Ordinance. It is not uncommon for there to be a lot of confusion and a lot of...
So I realize that you are effectively conceding that there's ambiguity, but do you have a position on what the intent was, whether the intent was to require a buffer in this kind of situation?
I would answer that in two ways. One, if the court wants to resolve the ambiguity by looking at legislative intent, I think first we would look at 1.1.12, the legislative intent that the ambiguity be resolved in favor of the text rather than the table. If you want to go past that and look at the table, I think that the original intent has gone by the wayside. I think what happened is that the regulation of farms has evolved tremendously within the county and within the statutory framework, and this has been a holdover for it. I would point out that the zoning district, the entire county is zoned. We only have up to the ETJs, but the entire thing is zoned. When you have a bona fide farm, that doesn't get rid of the underlying zoning. The zoning still exists. And you can have a bona fide farm that exists not to the full extent of a parcel. The bona fide farm extends to the bona fide farm purposes. And you don't need a permit for it because it is statutorily, you're exempt from all zoning. So there's no notice to the local government. You don't have to. You could start growing a row crop, wheat field, behind your country store, that you're selling, drinks, Coca-Cola, and you start growing row crops out there. You don't have to tell us about it. We might not know it if we're driving around the street and looking because it's behind your store. You don't have to get a permit for it. That makes it so much more difficult nowadays than it might have been earlier when the ordinance was rife with regulations of farms. Most of that has been fettered out of the UDO. We still do regulate farms in some extent because we have agricultural support. There's an E. Districts. So we say that if you're a farm, we're going to give you even more rights to do it. But all of that makes it very, very difficult to look at this and know, what is an active farm? It's not defined anywhere. Agriculture is only defined in state statutes as a bona fide farm purpose that is beyond our scope. So we looked at the ambiguity. We tried to resolve it, and then. We think that's sufficient, and if that's not sufficient, then we would go and recognize that property rights, zoning is a derogation of property rights, and we have to liberally construe them for the free use of property. And I know this is a weird situation where the local government, Orange County, is saying this, but we are recognizing that if we are going to construe this, if we're going to liberally construe this for the fair use of property, that we're going to need to rewrite our ordinance, and we can come back and we could rewrite the text and say, hey, it's going to be for districts or use, and whichever one is more strict. we can do that. But until then, we're going to let the free use of property go ahead. Happy to answer any questions, but seeing not, I'll try to end it there. Thank you, Your Honors.
Thank you. Rebuttal?
With respect to the question of the county conceding the liberal construction in favor of free use of property, I would simply point to the UDO 1.1.18 interpretation, in which it states the interpretation and application of this ordinance, all provisions shall be, subsection B, liberally construed in favor of the governing body. With respect to how to define a farm, the definition of active farm, et cetera, the UDO itself specifically states in section 10.1 that farming is defined as the use of land consistent with the state of North Carolina's definition of farming as contained in the general statutes. It also states something similar under section 1.1.8, bona fide farm, and that state statute is completely consistent with Ms. Arter's farm operations, which are outlined in detail in her sworn statement that's in the record. And then finally, I would add that Mr. Bryan just explained to this court that for a bona fide farm use, it doesn't have to operate on the entire parcel and be a portion of the parcel, because non-farm activities are subject to zoning requirements on any given property. And so there can be a bifurcation there. And I would submit that that is exactly why the language in 6.8.6C location separates and distinguishes between locating the buffer nearest the adjacent streets, land uses, or zoning designations. So again, we have this section C that's completely consistent with D. And I would submit that the interpretation of this, as read as a whole, can come to a harmonious interpretation that does not void, as Justice Dietz pointed out, putting your hand over this portion of it and wiping out 4 columns. And again, in Yancey, which is most oft cited for this principle of zoning and derogation of common law property rights, it does state that zoning ordinances should be given a fair and reasonable construction in light of their terminology and objects sought to be attained, and the natural import of words used in common accepted usage, and the setting in which they're employed, and the general structure of the ordinance. It goes on to say zoning regulations are in derogation of common law rights, and they cannot be construed to include or exclude by implication that which is not clearly in their express terms. But I would submit that it is, in this case, in the express terms, that there is a buffer between active farm and R1. And this is not a situation where you have well-founded doubts as to the meaning of obscure provisions. This is a black and white clear provision that we're facing, and so I see my time is done. Thank you very much.
Thank you, counsel. Thank you to both. Mr. Porter.